Ready, start. Ingredients of the alleged offence charged were not even prima facie established against the appellants. Full stop. Charge leveled by the prosecution against the appellants was groundless. Full stop. FIR was totally silent about any overt act of the appellants. Full stop. Appellants were not present at the place of occurrence when the incident took place. Full stop. There was no negligence on the part of the appellants, not to speak of having any knowledge or intention to cause the death of the two employees or such bodily injury as would likely cause their death. Full stop. Even if all the statements of the witnesses were considered and accepted as correct, the trial would not end in conviction of the appellants. Full stop. Going ahead with the trial would be a futile exercise. Full stop. There were no materials to show that appellants had committed the offence as charged. Full stop. In these circumstances, appellants sought for discharge as contemplated under section 227 of the CRPC. Full stop. Learned Additional Sessions Judge, Pune, wide his order dated 1/4/2017, dismissed both the discharge applications. Full stop. He held that the two appellants were certainly not oblivious of the fact that they had not provided safety gear to the employees, which was certainly dangerous to them as they got exposed to electrocution risk. Full stop. Learned Additional Sessions Judge was also of the view that there was much force in the argument advanced on behalf of the prosecution that there was sufficient material justifying framing of charge against the accused for the offence punishable under section 304 part 2nd read with section 34 IPC. Full stop. In that view of the matter, the discharge applications were dismissed. Full stop. Aggrieved by the aforesaid decision, appellants preferred criminal revision application number 269 of 2017 before the High Court. Full stop. After going through the materials on record and after hearing the parties, High Court was of the view that there was strong suspicion against both the appellants for committing the offence for which they were charged. Full stop. It could not be said that there were no grounds to proceed against the appellants. Full stop. No case for interference was made out. Full stop. Hence, the revision petition was dismissed while the judgment and order dated 2/11/2017. Full stop. Assailing the aforesaid judgment dated 2/11/2017 of the High Court, appellants preferred the related SLP criminal close number 9928 of 2017. Full stop. By order dated 9/1/2018, this court had issued notice and granted stay of further proceedings in Sessions case number 749 of 2014 pending on the file of the Additional Sessions Judge, Pune. Full stop. The matter was heard on 30/4/2024 when leave was granted. Full stop. Hence, the appeal. Full stop. Learned Counsel for the appellants submits that both the trial court and the High Court fell in error in rejecting the discharge applications filed by the appellants. Full stop. Though the prosecution had submitted charge sheet alleging commission of offence under sections 304A/182/201 IPC read with section 34 IPC, learned magistrate while committing the case to the Court of Sessions concluded that there was material to invoke section 304 part 2nd IPC. Full stop. Trial court took the view that there is sufficient material justifying framing of charge against the appellants for the offence punishable under section 304 part 2nd read with section 34 IPC. Full stop. Interestingly, High Court proceeded on the basis that appellants were accused of committing offences under sections 304 and 304A IPC while dismissing the revision application of the appellants. Full stop. Learned Counsel submits that no offence is made out against the appellants under section 304 part 2nd IPC or even under section 304A IPC. Full stop. The two deceased employees of appellant number 1 were working on the signboard as part of cleaning the front side of the shop. Full stop. It was an accident that they got electrocuted and fell down, because of which they suffered multiple injuries leading to their death. Full stop. The only reason for filing of charge sheet against the appellants is that, according to the prosecution, appellants had not provided safety equipments to the two deceased employees, such as rubber shoes, safety belt, etc. Full stop. He submits that non-furnishing of such equipments would not make it a criminal offence. Full stop. Adverting to the order of the High Court, learned counsel submits that the High Court proceeded on the basis that it was expected from a prudent person to have provided the deceased employees wooden scaffolding instead of an iron ladder.